You've probably heard of a prenuptial agreement. They're common enough that they even have a nickname, the Prenup. But you may not know much about a similar agreement that can do much of the same, the postnuptial agreement. We're eForms, the world's largest online database for fillable legal forms. In this video, we'll cover what prenuptial and postnuptial agreements are, what the laws are for each type of agreement, and when each type of agreement might be of use. Be sure to watch to the end of this video to find a link to create a prenuptial agreement customized to your situation. First, what are prenuptial and postnuptial agreements? Both prenuptial and postnuptial agreements are contracts that enable couples to establish rights and responsibilities should their marriage end in divorce or death. Although the agreements can apply in both contexts, it's common for other estate planning documents like wills and trusts to cover what happens at death. As a result, prenuptial and postnuptial agreements are most commonly associated with divorce. Rules about divorcing property during divorce vary depending on what state a couple is living in, but one commonality is that judges in divorce cases have a lot of discretion to divide a couple's property, and sometimes one spouse may find the division unfair. Both prenuptial agreements and postnuptial agreements help provide a sense of certainty, because in the event of a divorce, judges are generally obligated to defer to them. How are the two types of agreements different? Both prenuptial and postnuptial agreements must be written down and signed by both parties, but as you may have guessed from the name, prenuptial agreements are signed before a marriage begins, while postnuptial agreements are signed after a couple is already married. Prenuptial agreements become effective as soon as a couple's marriage is official, while postnuptial agreements become effective as soon as they are signed. Although it may not seem like much, the difference in timing means that prenuptial agreements and postnuptial agreements are considered very differently under the law. Most states impose different requirements, and while every state allows prenuptial agreements, some states carefully restrict postnuptial agreements. Are there ways to challenge prenuptial and postnuptial agreements? Even if a prenuptial or postnuptial agreement has been signed by both spouses, one spouse may claim that it shouldn't be enforced. With prenuptial agreements, courts may refrain from enforcing otherwise valid agreements if they are grossly unfair, or if there is evidence that one spouse signed under duress, without access to legal counsel, or without clear information about the other spouse's finances. These same considerations apply to postnuptial agreements, but they are usually even stricter. Some states prohibit certain terms in postnuptial agreements or apply greater scrutiny to them than they do to prenuptial agreements. Unfortunately, these distinctions are usually very complicated, and you may require the assistance of an attorney to plan around them. Check this video's description for a link to our blog post about this subject for more detailed explanations. Both prenuptial and postnuptial agreements can be valuable estate planning tools, but there are important legal differences between the two. For an official prenuptial agreement that can meet your requirements of your state, click the link below. And don't forget to subscribe to see other videos on related legal issues.